Good afternoon, Miss Bridgewater.
Afternoon, Your Honor. How are you?
I'm doing well. Hope you are as well.
I am.
Thank you. The SAP reset date.
July the 8th. I was corrected on it yesterday. I saw you laughing.
You had me all confused.
I know. I have that effect, okay?
Afternoon, Miss Fall.
Good afternoon, Your Honor.
Afternoon, Officer Milton. You want to get started in ACDC while we wait for courtroom two?
Good afternoon. I have Miss Williams and Miss Ross. I don't have their position numbers. And my last one which is Miss Jennifer Almeida. She's talking to Miss Tucker right now.
Okay, thank you. Representing Miss Williams.
Attorney Mike McLean.
Okay. Mr. McLean, can we proceed with Miss Williams, position number 19?
Yes, Your Honor. I believe the mute is off now.
Okay, very good. Let me speak with everyone first. Good afternoon, ladies and gentlemen. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. We're providing you with the assistance of a public defender this afternoon if you choose to utilize their service. Ms. Williams, you have been charged in case 25 CR 003542F with 3 counts of battery family violence, simple battery family violence, and simple battery. Mr. Howard, good afternoon. Is there a history?
4 total. Got an open pretrial case for shoplifting. 2013 battery DV dismissed. 2010 shoplifting dismissed.
Thank you. Afternoon, Mr. Sirocco.
Good afternoon, Judge. Can you hear me?
Yes, I can hear you.
All right. This incident took place June 23rd of this year at 240 Howell Drive, Southwest Atlanta. Law enforcement responded to a domestic dispute and upon arrival met with the callers who were trying to stop the defendant from causing further injuries to the defendant's mother on scene, the first victim, Miss Elizabeth Williams. The officer initially observed numerous broken furniture items, including a table, as well as scattered articles of mail, broken picture frames, made contact with the victim, Miss Williams, Elizabeth Williams, and Alan Williams, who is the defendant's brother. They explained that the defendant, who lives with them at the location there, became irate when Elizabeth had asked her daughter to stop cooking late hours. Defendant got aggressive, started throwing canned items at her mother before starting to run after her inside the household. Alan Williams heard the disturbance from his bedroom and came outside to check on the two. The defendant had a small wooden broken table leg that she was swinging at Miss Williams. Alan Williams tried to intervene and was struck on the side of his lip and the jaw with the table leg, causing a cut. And during that struggle, to calm and sort of restrain the defendant until police arrived, the defendant was scratching the two of them. There were scratches on Mr. Williams' stomach that police observed and Miss Williams' arm. The officer was able to observe all these injuries with an additional injury, another laceration to Miss Williams' foot, the victim, Miss Williams' foot, from fleeing from the defendant in the process. We have spoken with both victims. They confirmed that the information on the warrant is correct and that they believe there is a substance abuse issue because they're not sure what it is, what that substance is, but as of right now, they believe she has a drug problem and they say the defendant is not welcome to return to the home because of all the problems that she's been causing, and especially with destroying things. They're concerned about being subject to eviction, and so they're asking for a stay away. But they are also asking for no further violent contact. They believe the defendant needs alcohol drug evaluation and treatment and a social worker visit alongside that with assistance for housing, because she doesn't have a place to reside otherwise. And I believe we would ask the court sound for both victims. I don't believe Miss Williams is on. Mr. Williams might have been able to make it. But in any case, the state is recommending a $4,000 total surety, $1,000 on each of the battery family violences, $500 on each of the simple battery family violences on account of the prior battery family violence case. While it was dismissed, this is not her first time around with a case like this. For her to complete the family violence intervention program, undergo alcohol drug evaluation and treatment, and social worker visit for housing. And for the time being, we believe no further contact with either victim is appropriate. This is a fresh incident, and it's just happened yesterday, actually. No drugs, weapons, or alcohol while out on bond.
Yes, Mr. McLeod. I'm sorry, Mr. McLean.
Yes, Your Honor. Mays High School in 2011 graduation for Ms. Megan Williams, 32 years old. She can live with friends, not at Howell. She has had jobs in warehouses and also unarmed security at other places. We would ask the court to consider a signature bond. I realized that there was a dismissed VFB that was mentioned. I didn't hear that it was the same alleged victim, but I would emphasize that it was dismissed and hope then that it was dismissed because it wasn't true. So we would ask the court to consider a signature bond. If not that, 1,000 surety.
Okay, for each charge, it's going to be
Judge,
five.
before you make your order, could we sound for the victims?
If either Elizabeth or Alan Williams are on the line and wish to address the court, now is your opportunity. Does not appear so. For each of the counts will be a $500 good bond, makes for a total of a $2,500 good bond. No further violent contact with either of the alleged victims. Stay away from the Howell Drive address. She can go back to that address on one occasion with law enforcement to retrieve any belongings. Social worker visit to assess for BHET and housing if necessary. No drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Williams.
Number 7, Ms. Fan.
Ms. Williams, Mr. McLean will give you a call after court today to discuss any issues that you might have. Mr. McLean, she has her hand up, so would you speak with her after court today, please?
Yes, Your Honor. As soon as this phone is free over here, I give her a buzz in between other people's clients.
Okay, thank you.
Thanks.
I'm sorry, tell me again where we're going.
Number 7.
Okay. Yes, good afternoon, Ms. Vance Edenis. You have been charged in case 25 CR 003530G with 2 counts of battery and 2 counts of simple battery. Is there a history, Mr. Howard?
11. I got an open drug DUI case. I didn't see any violent arrests that I recall. That's it.
Thank you. Ms. Falk?
Yes, Your Honor. And most of Miss Fan Edenis, or the defendant's history, surrounds DUIs and drugs. This incident happened February 19th of 2025. Miss Ethel Swearington was at the Liberty International Church at 1362 Metropolitan Parkway in Atlanta. She is just to let you know the relationship, she is engaged to the defendant's brother. Apparently, there have been issues for a couple of years between the defendant and Miss Swearington. But on this date, Miss Swearington saw the defendant's daughter on the ground. She went to pick her up off the ground because she didn't want her dress to get dirty. And the defendant became very upset, began cursing at her, screaming at her, said she was going to, don't touch my child, yanked the child out of her arms, told her to shut the, started yelling and screaming until the father, who is the defendant's father and the pastor of the church, intervened and wanted the two of them to go into a different room to have a discussion and kind of talk things out. She went into the room. Miss Swearington initially was hesitant to go in there because of how the defendant was acting, but finally agreed to do so, went to go into the room to talk, and was suddenly attacked by the defendant, sustained scratches on her face, lip, behind her ear, on her neck, and had her braids pulled out. She was finally pulled away from the defendant, and she fell to the ground, causing her to aggravate an older injury in her neck where she had some screws there. And the defendant continued to stand over her, punching her in the head and face and kicking at her once she was pulled away from her. We've had an opportunity to speak to the defendant, who is here in court. As you've heard, speak with Miss Swearington, who's here in court. We have had we did look at the defendant's history, which is 11 cycles. The defendant currently has a $2,500 surety bond on the count 1 of the battery. For some reason, the magistrate court gave a bond on one count, no bond on the other count. We're asking for an $8,000 split bond, $3,000 on the battery, $1,000 on the simple battery, and then $3,000 signature on the second battery, $1,000 signature on the second simple battery, for a total of $8,000 split, $4,000 surety, $4,000 signature. No further contact with Ethel Swearington. Stay away from her residence. No alcohol, drugs, or weapons. And we're also asking for 3 days of anger awareness.
I'd say about 350 for bond, probably.
And we would like to sound for Miss Ethel Swearington at this time.
If Ms. Swearington is on the line and wishes to address the court, now is your opportunity.
If you don't have the money to make your bond, we'll sit in jail.
Okay. Who's representing Ms. Fan? $350.
Should be Miss Tucker.
Tucker, are you with me?
$350. Yeah. I'm not lying.
Yes, Your Honor.
Is this your case?
I'm sorry, I was just interviewing. So I just tuned in. Could you tell me the position you guys are on?
Position number 7. Ms. Fan, Edness.
Okay.
In courtroom 2, would you mind muting for us there? We're getting Mr. McLeod a little. Thank you. Mr. McLean, excuse me.
Okay, yes, this is my case. Miss Edness. So Miss Edness is. Can you tell me the state's recommendation? I'm sorry.
Yes, I can repeat that. The state's recommendation is an $8,000 split bond, $3,000 on the battery, $1,000 on the simple battery as a surety bond. On the second count of battery and simple battery, $3,000 signature, $1,000 signature. Stay away from the residence of Ethel Swearington. No further contact with her. No alcohol, drugs, or weapons, and 3 days of anger awareness.
Okay, thank you. Your Honor, Miss Edness is 44 years of age. She's an Atlanta native. She has obtained her GED and she's currently employed as a manager at a Bojangles. The incident location occurred at her family's church. She has no objection to no contact with Miss Ethel. And we are requesting the lowest bond that the court will allow in this matter. This case has already went before a civil court, and Miss Ethel did choose to voluntarily drop the charges in this matter. So we are asking for the lowest bond on her behalf.
For each of the batteries will be a $2,000 signature bond through pretrial level 2. For each of the simple batteries, a $1,000 signature bond through pretrial level 2. Makes for a total of a $6,000 signature bond through pretrial level 2. No further contact with Ms. Swearington. Stay away from her residential address. At this point in time, stay away from the Liberty International Church. No drugs, alcohol, weapons while out on bond.
And
Good
Your
luck.
Honor,
Your Honor, go ahead, spoke.
oh, sorry. I just wanted to see if the person on Samsung is Miss Swearington. Samsung SM, you Miss Swearington? Can you nod or shake your head yes or no, because we can't hear you? You're muted. Okay, that is Miss Swearington. Your Honor, if we just may briefly hear from her, I think she was having some trouble with the technology.
Yes, that's fine. Ms. Swearington, if you will unmute yourself for me.
And Miss Bridgewater, if it's possible, or Miss Grace, can you send her one of those unmute notifications?
I did, Ms. Falk.
Okay, appreciate that, Miss Grace.
And while she's trying to figure that out, did you have something, Ms. Tucker?
Yes, I was going to ask in regards to the stay away from the church location. It is Miss Eden's family's church. Her grandfather is the bishop at that location, and the alleged victim, Miss Ethel, is actually not allowed to return back to that location. And so because it is her family's church and she attends there regularly, we were asking that we were objecting to the stay away and asking that the court allow her to be able to return back to that location.
Okay, let me see if I can hear from Ms. Swearington, and I will.
Yes, Your Honor.
I'm happy to hear from you, Ms. Swearington, but you're gonna have to figure out, normally there are like 3 little dots. You might have to hit those so that you can unmute yourself, or there should be a microphone there, possibly. Okay, I'm happy to hear from you. If you can figure that out, I'll have to come back to you if you do figure that out at a later time.
Your Honor, really quick question. Did you order anger awareness as part of the pretrial services bond?
I did 3 days. I think there was a request, which is what I ordered.
Thank you, Your Honor.
You're welcome. And as long as if Ms. Swearington is not at the Liberty International Church, then Ms. Fan will be allowed to go back there. So I won't restrict her from going to her church, but Ms. Swearington cannot be there. Okay. Who do we have next? I don't believe that Ms. Swearington's able to figure out her device there, unfortunately.
Number 13, Ms. Miles.
Good afternoon, Ms. Miles. You have been charged in case 25 CR 003541F with 2 counts of battery and 1 count of simple battery. Is there a history, Mr.
Your
Howard?
Honor, before we proceed, how are you?
Yes, good afternoon, Ms. Harrison.
This is actually a co-defendant case with position 18.
Okay.
Ms. White, if you wanted to bring them up at the same time, the facts are the same.
Don't have the space. She's next.
Okay.
Okay. So Is there a history for Miss Miles, Mr. Howard?
No.
Okay, first arrest, thank you. Yes, Ms. Harrison.
Your Honor, just one second. Okay. Okay, Your Honor, on June 23rd, officers were dispatched to a 911 call at 1634 Hollywood Road, which is the Reserve at Hollywood apartment complex. When they arrived, they separated the parties and spoke to the victim, Miss Taniqua White, and she stated she was going outside to get her kids from her mother's vehicle. And when she was outside, her sisters were talking to her about her baby's father who recently passed away. She told her sisters she did not want to discuss that with them. And then Miss Miles, the defendant here, got out of the car threatening to fight her. They ended up fighting, and Miss White subsequently jumped in the fight. So it was essentially a 2-on-1 situation. Officers observed bruises to Miss White's face and also a black eye on the scene. The victim's mother also spoke to officers and informed officers that she was coming to drop off clothes for the kids, for both of her children. And the defendant and Miss White jumped on Mrs. Taniqua White. Yeah, we were not able to get in contact with Miss White today, Your Honor, but the state's recommendation is a signature bond through pretrial services.
No, I'm here. I'm here.
Oh, are you here? Okay,
Yeah,
one
I'm
second.
here.
Give me a chance to speak in just a second. We're going to ask for a signature bond through pretrial services, no contact with the victim, a stay away from the incident location, and no drugs, weapons, or alcohol while on bond, and we'll sound for Miss White.
Yes, Miss White, I understand that you're here. I need for you to unmute yourself and activate your camera for me. Yes, ma'am. If you can raise your right hand. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes, ma'am. What would you can place your hand down. What would you like to tell the court?
Yeah, I just like I told the person who called me, I just was telling her like I don't want to have no contact with my sisters. These are my blood sisters. We're not from Georgia, and it's just us down here with my mom. The fight wasn't over my baby daddy like at all. I don't know where that came from. They just wanted to make it seem like it was, but it wasn't. They fought me over somebody else. The problems they had with somebody else. I just didn't have time for it. I'm still grieving. I lost my baby father in September of last year, due to gun violence. And I've just been trying to grieve, and they just been nicking at me, and I just cut them off. I still got messages from the time that Miss White texted me, and she was like, "You good?" And I was like, "I'm good." But then, like the next day, you fight me, like I don't understand. And then Miss Miles, I don't understand where her beef came in at with me either, because we was just talking the day before the fight too. Like it's just confusing to me. So I just rather not deal with them. I don't want no dealings. I don't want them to be around me. They're not my sisters. And I just want them to know that they're wrong.
And Ms. Tanika, the Reserve at Holly, those apartment complexes, do you live there?
Yes, sir, I do.
And do they live there as well?
Michaela, they do. Michaela do. She has an apartment. Miss Miles, she was just staying there. So I'm assuming she stayed there too.
Okay, but y'all don't live in the same apartment?
No, we don't live in the same apartment, no, sir.
Okay, all right. Thank you for being here this afternoon, ma'am.
Thank you.
You're welcome. Yes, good afternoon, Ms. McLeod. Is this your client?
No, Your Honor, I represent the other Miss White.
Oh, okay. Thank you. Mr. McLean, yes.
Your Honor, no objection to the signature bond. She works in a warehouse, has been a homemaker, and has graduated from Shaw Academy as high school. Your Honor, she'll figure out housing. If Your Honor, I don't know how close these places are. If there's a problem with housing, she's resourceful and 23, so she'll figure it out. But if they can stay apart from each other in the same complex, that would be super too.
Okay, for each count will be $1,000 signature bond through pretrial level 1, makes for a total of a $3,000 signature bond through pretrial level 1, 1 day anger awareness, no further contact with Ms. Tanika White, stay away from her apartment, no drugs, alcohol, weapons while out on bond. Good luck to you, ma'am.
Next we have Markia Ross.
Can we do this, since these are the same, can we do Micaiah White since, it's the same incident? So I'll be right back to you, Officer Milton. Yes, good afternoon, Ms. White. You have been charged in case 25 CR 003534A with 2 counts of battery and 1 count of simple battery as well. Is there a history, Mr. Howard?
Got a 2016 obstruction and a vice charge. That's it.
Anything to add, Ms. Harrison?
Nope, Your Honor, that was the same history the state had.
Same recommendation?
Same recommendation, the facts are the same.
Okay. Yes, Ms. McLeod.
Yes, Your Honor, we are fine with the signature bond for my client. Of course, my client denies the allegations. She has given me a totally different version of what happened. We are also okay with no further contact.
Okay. As such, it will be $1,000 signature bond through pretrial level 1 for each charge, makes for a total of a $3,000 signature bond through pretrial level 1, 1-day anger awareness, no further contact with Miss Tanika White, stay away from her residential address, no drugs, alcohol, weapons while out on bond. Good luck to you, Miss White.
Thank you.
You're
Thank you, Your
welcome.
Honor. That concludes my business before the court. May I be excused?
Yes, we'll see you next time. Thank you, Ms. McLeod. Have a good
You're
afternoon.
welcome. You too. Thank you, Judge.
Yes, we can go back to ACDC now. Who do we have there again? Oh, I think we lost Officer Milton. So can we go on? Anybody? Courtroom 2?
Position number 4, Mr. Coleman.
Okay. Good afternoon, Mr. Coleman. You have been charged in case 25 CR 003528C with criminal trespass. Is there a history? Mr. Howard?
19 on probation in the cab for shoplifting. 2024 FTA, 2 trespass convictions from 2024, 2 from 2023, and 2 from 2019.
Spark.
Mr. Howard, really quickly, is he not still on probation on those 2 2024 criminal trespass? Because based on my calculation, he still should be.
He probably is. I just saw
okay.
the convictions. I didn't look at the SAP stuff.
Oh, got it.
Okay.
Understood. Okay. Your Honor, this happened on June 22nd, 2025 at 3067 Washington Road in East Point. The defendant went into the BP gas station at that location without the owner's consent. The owner is Sanak Zafarazi, who stated that he had been issued a criminal trespass warning the defendant had on June 6th from that location and then reappeared at that location 16 days later. The defendant had entered the front door with another paying customer and he asked him to leave. The defendant then went outside and stood outside of the store waiting for the paying customer to buy him snacks. At that point, the police came and took Mr. Coleman under arrest when they told him that he was not supposed to be there. And that is all. The defendant currently has a $600 preset surety bond. We're asking that remain as set. No further contact with Sanak Zafarzi. Stay away from the BP at 3067 Washington Road in East Point. No alcohol, drugs, or weapons. And I see what happened on the 24 CR 003808A case and the 24 CR 008005Y case, which are both cases he most recently pled to. He received suspended sentences on those cases and a stay away from the Polaris at 3072 Washington Road. So there is a lengthy history here of criminal trespass culminating in the 2 most recent convictions, which I believe he was convicted on those cases in December, if I'm correct. at the SAP calendar, the last SAP calendar. That's all for the state.
If Mr. Farazi is on the line and wishes to address the court, now is your opportunity.
I can't hear you. You must.
Ms. Tucker?
Yes, Your Honor. Mr. Coleman is 58 years of age. He's resided in the Atlanta area for over 10 years. While he was able to provide me with a mailing address, he does not currently have a residential address at this time. He has obtained his GED, and he has just recently gained employment at the Pizza Hut. He has 4 children. While he does have some criminal history, we are requesting a signature bond on his behalf. He, due to his financial circumstances, his homelessness, as well as just obtaining this job, he's actually very concerned about losing the job that he was just able to maintain. And he maintains that he was outside of the store. He only came over because someone offered to buy him something. He was not trying to cause any harm, so we are requesting a signature bond on his behalf. He would not be able to make a $600 surety today. Thank you.
And Your Honor, just a brief modification. One of those, the last conviction was January of 2025. The conviction previous to that was August of 2024. And so those were recent convictions. If there is concern about his residential status, we would ask for a social worker visit as well.
Okay. Ms. Tucker, something's going on with Mr. Coleman. He is, I do want him to have a social worker visit to assess for a BHET and any housing issues. We'll see him back at the SAP calendar on July 8th and have the social worker report to me at that time. But today it'll be $1,000 good bond. Stay away from the BP on Washington Road. No further contact with Mr. Zafarzi. The social worker visit, and no drugs, alcohol, weapons while out on bond. I'll see you back on July 8th if you don't get out, Mr. Coleman. See if we can get you some services. Who do we have next?
Miss Ross, Marcia Ross.
Excuse me, y'all need to separate or I'll put you out. I'll talk if I put you out. Thank you. That's it, I'm
If you can go ahead and mute there for me, courtroom 2, if you don't mind. Good afternoon, Ms. Ross. You have been charged in case 25 CR 003474C with 2 counts of battery family violence, 2 counts of simple battery family violence, and 2 counts of cruelty to children in the 3rd degree. Is there a history, Mr. Howard?
3rd adult, 2024 shoplifting, possession of a knife or a firearm. During the commission, possession of marijuana dismissed. 2019 simple battery DV dismissed.
Thank you. Mr. Sirocco?
Thank you, Judge. This incident took place June 22nd, 2025 at 1940 Rambling Drive, Southwest in Atlanta. Law enforcement responded to a fight in progress call. Upon arrival, the officer made contact with the parties, the victim, Quan Roberts, and the defendant, who were still engaged in a verbal dispute outside the parking lot of the apartment complex at the location. The officer made contact with Mr. Roberts, first to explain that the defendant, who had been staying at his location since April, had been asking him to take her home, but he wouldn't. And the victim then explained that he had ordered a lift for her, paid the driver extra to wait, but the defendant refused the ride because she didn't like the type of vehicle. The argument stemmed from the victim not coming home on time, ultimately, which made the defendant aggressive. She proceeded to kick his vehicle, leaving scuff marks on the left side when the victim then approached. After she had done this, she began grabbing his hair and pulling it out of his head, causing a bald spot or bald spots, at which point he pushed her off him. The altercation continued inside of the apartment where multiple children were present. 2 juveniles, MM and IW are the initials. And the physical altercation continued in their bedroom when the victim was grabbing the defendant's 1-year-old child. The defendant then admitted that she did kick his truck and pull his hair out when police spoke with her. He had marks on his face and missing hair on his head that, with that mark, including a laceration that was caused to the left side of his nose from her striking him. The defendant was determined to be the primary aggressor based on the marks and the injuries, the statements here. Defendant was then arrested. As you heard from pretrial, she does have that simple battery family violence case from 2019 that was dismissed, but a case nonetheless. We have spoken with the victim. He explained that the information in the warrant is correct, that the defendant has been staying with him since April. He requests to drop the charges. He stated he just wanted the defendant out of his house and didn't want any of this. However, he's requesting no further contact. He's requesting a stay away. He states he's not in fear of the defendant, but nonetheless affirmed that the defendant needs anger management classes. States his child and the defendant's kids were present during the incident. I believe the 2 juveniles listed earlier were actually the defendant's kids. And let's see, he is requesting the keys to his house be returned to him. And that is about it. If we could sound for Mr. Roberts when appropriate. The state's recommendation for this, based on the previous battery family violence case, or the simple battery family violence case from 2019, is $4,000 total surety, $1,000 surety on each of the battery family violence charges, and $500 sureties on the remaining counts. For her to complete FFIB, have no further contact with Quan Roberts, stay away from 1940 Rambling Drive Southwest in Atlanta, and no drugs, weapons, or alcohol while out on bond.
Mr. Quan Roberts is on the line and wishes to address the court. Now is your opportunity. Does not appear so. Mr. McLean?
Your Honor, Ms. Ross is 25, has a 12th grade education, went to Crim, graduated in 2018. Your Honor, she has been a customer service representative on the internet from home for 3 years. She has done restaurant work. She's done security work. She's been a Walmart cashier. I didn't get that from her. I got that from Odyssey. We would ask the court to consider a signature bond in this case, Your Honor. The 2019 is dismissed as noted. Thank you. And of course, this did not happen at her address, so that won't be involved.
For each of the batteries will be a $2,000 signature bond through pretrial level 1. For each of the simple batteries, a $1,000 signature bond through pretrial level 1. For each of the cruelty to children, a $500 signature bond through pretrial level 1. Makes for a total of a $7,000 signature bond through pretrial level 1. 2 days of anger awareness. No further contact with Mr. Roberts. Stay away from the Rambling Drive address. No drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Ross.
Position number 10, Mr. Holmes.
Good afternoon, Mr. Holmes. You have been charged in case 25 CR 003537Y with promotes or organizes an exhibition of illegal drag racing or laying drags. It's my understanding that this is Mr. Holmes' first arrest. Ms. Harrison?
Yes, Your Honor. On June 7th, an Instagram account labeled Beyond Atlanta posted a flyer to 11,500 followers promoting a car meetup at 2975 Headland Drive in Southwest Atlanta. The flyer was titled Saturday Night Heat and displayed a Beyond Atlanta logo in the top center of the flyer. It informed followers to meet up at the address at 10 p.m. with a subtitle at the bottom that read "Sliders on Steroids." Officers were investigating this as an ongoing issue in the city of Atlanta, the drag racing circles. And they came across this post and they actually responded to the area to monitor the meetup. When they arrived on the scene, they observed about 100 cars gathered in a parking lot with smoke rising from the crowd and cars burning out tires on the pavement. They observed a BMW doing donuts in the parking lot and entertainment for the crowd. The event was shut down by police and 4 people were arrested. The owner and operator of the Instagram page Beyond Atlanta is found to be the defendant, Mr. Holmes. Officers found this to be true based off of a search warrant, based off of a separate car meetup that turned into a display of burnouts and donuts. That event occurred in March of 2025. So officers reached out to the defendant over the phone in an attempt to discuss these events he had planned in Atlanta in April of 2025, and he agreed to meet with investigators, but he never showed up. He did, though, confirm during the conversation that he knew he was Beyond Atlanta and did not deny being the owner of the account. And this warrant was issued for his arrest. Your Honor, there is major safety concerns due to these activities taking place in public places, often with cars traveling at high rates of speed and spinning and spiraling out of control. That being said, the state's recommendation here, in light of these allegations, is a preset $2,500 surety bond. We're in agreement with that. We'd like for it to remain as set. We're asking for no drugs, weapons, or alcohol while the defendant is on bond. And yeah, we just want to state that we do have an interest in stopping this dangerous activity, and that is the reason for our recommendation, Your Honor. And that'll be all for the state.
Thank you. Mr. McLean?
Bonds, they're already listed, may come off a schedule, but I don't know that any particular evidentiary thought went into it, but he lives on Friendship Road in Beaufort. He's 19, despite his young age. He has, the leadership qualities we encourage in people his age. He's been a manager at a restaurant for 2 years. He has also worked at a car wash, Your Honor. He has a high school education. We would ask the court to give him a signature bond. He's got stable mailing address, and he's got I quizzed him about, he's 19, and I said, I don't know if Your Honor will require an adult co-signer. He's got friends in their 30s if his parents can't be reached by phone.
If nothing further, it will be a $5,000 signature bond through pretrial level 1. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Holmes.
Thank you.
We're gonna do position number 5, Mr. Marcus.
Yo.
Good afternoon, Mr. DeMarcus. You have been charged in case 25 CR 003531A with willful obstruction of law enforcement officers. Is there a history, Mr. Howard?
8, 2013 suspended license, 12 theft of property, 2011 driving without a valid license, trespass. That's it.
Ms. Falk?
Yes, Your Honor. I believe that most of Mr. DeMarcus's cases were out of another state. If Mr. Howard could just verify that for me. I think it was Tennessee, if I'm correct.
You are.
Thank you, Mr. Howard. So this incident happened on June 23rd of 2025. The defendant was walking along a controlled access highway, which is in violation of Atlanta City Ordinance 156-267. The officer advised him several times he was in violation of the city ordinance and offered to drive him up to the exit so that he would no longer be in violation. The defendant refused, saying that doesn't make any sense. There isn't a law for you to just give me a ride off the highway, and then began walking past the officer and continued to walk on the controlled access road in violation of the ordinance. At that point, the officer attempted to take him into custody. The defendant began tensing away from the officer, pulling away from the officer, and it caused them to actually go over the side of the railing. The officer was able to hold him in place because there was actually going to be a drop off. If they had continued to roll, they would have dropped off about 100 feet over the side. So the officer continued to hold him until another officer arrived and they were able to take him into custody. The state's recommendation on this is going to be the current bond is set at a $1,000 surety bond. The state is going to ask that remain as set due to the fact the defendant's history, I believe, is almost exclusively out of Tennessee, and we do have concerns that he doesn't have any ties to community. Additionally, his behavior and his actions almost caused them to roll off an embankment and go down 100 feet. Luckily, the officer realized where he was and was able to pin him down until he could get some backup. We're also asking for no alcohol, drugs, or weapons at this time. That's all for the state.
Thank you. Ms. Tucker?
Yes, Mr. Powell is 34 years of age. He's actually been in the Atlanta area for about 13 years now.
I want to make sure we have the right person. You said
DeMarcus, his last name is Powell. They have
Okay.
him on the calendar as DeMarcus Dwayne. Dwayne is his middle name.
Okay, so it's
on the GCI it's Power too.
okay.
But
I just wanted to make sure. Okay, thank you.
Yes, Your Honor.
I'm sorry, Ms. Tucker, you can proceed.
Thank you. He's 34 years of age. He's actually been in the Atlanta area for 13 years now. He is currently homeless. However, he's obtained up to a 9th grade education. He's not currently employed due to experiencing job loss at the end of last year. So he is currently looking for a job. His last arrest was in 2013, and it was for driving on a suspended license. So with his history going back 12 years, I don't think that it being exclusively in another state should hinder him from getting a signature bond. He's been here for 13 years. We are asking for a signature bond. He wouldn't be able to make bond on $1,000 surety due to experiencing job loss and due to his limited history. That's what we're requesting at this time.
Does he have a place to reside at the present time, Ms. Tucker?
He is currently homeless.
Okay. I want to have him have a social worker visit to assist with housing. I also don't want to wait 2 weeks. Ms. Bridgewater, I'd like to put him on the SAP calendar for the 1st for me, please.
I will.
So if you will have someone speak with him, Miss Tucker, so that they can report back to me next week. So at this time, it'll be $1,000 good bond, social worker visit to assess for BHET and housing issues. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Powell.
Thank you.
Number 14, Mr. Pierce.
Your Honor.
Yes, good afternoon, Mr. Pierce. You have been charged in case 25 CR 003535H with criminal trespass and damage to property, simple battery, and 2 counts of terroristic threats and acts. Is there a history, Mr. Howard?
5th arrest, last was in April, North Carolina. I got felony stalking and DV protective order violation. 2012 contempt of court. It was for violating domestic violence order. 09 shoplifting conviction and has a TPO out of North Carolina. think it's a different victim. That's it.
Thank you. Mr. Sirocco?
Yes, Judge. So this incident took place May 2nd of last year at 4725 Walton Crossing Southwest in South Fulton. It's the Walton Lakes Apartments. The defendant was told to leave the location by the staff, and the officer spoke with the property manager there, Miss Mamie Simon, Meimi, Simon, as well as Mr. Connor Pruitt, who I believe also is an employee there. The defendant threatened both of them, stating that after he left the premises, he was going to return later and F them up. An officer personally reviewed the CCTV footage, which showed the defendant being aggressive with management staff, hollering and making threats on his way to exit the door. Ms. Simon explained that the defendant, as he was leaving, she was standing near the door, holding it, and he proceeded to kick it into her, striking her in the chest and kicking the door also into her foot with enough force to actually cause the door, which was wooden, to crack at the bottom. Warrant was issued for his arrest at that time, so this delayed arrest here. With respect to his history, given that he has, most of his history suggests he's primarily lived out of state. I know that violating domestic order, that was from 2012 in New Jersey. And then you have that fugitive from justice in New Jersey all the way up in 2024. And then beyond that, the North Carolina cases for felony stalking and DV protective order violations, both of those were this year. So that would suggest he is a flight risk and that he may well fail to appear for the next court date. So the state is asking for $2,000 total surety, $500 for each count, 2-day anger awareness, no further contact with Connor Pruitt, no further contact with Mamie Simon, stay away from 4725 Walton Crossing Southwest in South Fulton. Again, that's the Walton Lakes Apartments, and no drugs, weapons, or alcohol. We have not yet spoken with the victims in this case. We will continue those efforts, but we would nonetheless ask the court sound for them.
If Ms. Simon or Mr. Pruitt, if either of you are on the line and wish to address the court, now is your opportunity. Does not appear so. Mr. McLean?
Thank you, Your Honor. He is 34, and it was 13 months ago, Your Honor. What does suggest that he would not be a flight risk is that after he was released from Charlotte, North Carolina, they had said to him, "You've got a warrant in Georgia," and he turned himself in at the police station. So he's going to come to court and see to these charges. He's a high school graduate. He's been a marketer in the hospitality industry at a hotel. Before that, he sold appliance insurance, Your Honor. We would ask the court to afford him a signature bond.
Okay, for each charge will be a $500 good bond. Makes for a total of a $2,000 good bond. No further contact with either of the alleged victims. Stay away from the incident location. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Peelers.
Next, we have Jennifer Almeida.
Okay, that's position number 1. Good afternoon, Ms. Almeida. You have been charged in case 25 CR 003526C with battery family violence and simple battery family violence. Is there a history?
23. Open ag assault, simple assault. It's 24 PI 007824. 2020 FTA and probation. 2019 ag assault that was dismissed. 2019 trespass conviction. Got FTAs from 2017 and 15. 2015 criminal damage to property, 2nd degree, first offender.
Thank you. Ms. Paul?
Yes, Your Honor. This happened June 23rd, 2025 at 3631 Chattahoochee Circle in Roswell. The officers responded to that location and spoke with Keely Alameda. Miss Alameda is the daughter of the defendant. She stated that they were cooking. An argument broke out between the two of them. The defendant threatened to beat her and strangle her. And so Miss Almeida went to her room in order to separate. The defendant then followed her into the room, continued to berate her, and started banging her phone in an attempt to break it. The defendant then put her hands on Miss Almeida. So Miss Almeida retaliated and put her hands on the defendant. At that point, the defendant struck her in the throat, kind of like a karate chop to the throat, which caused a visible red mark to her throat right where she had been hit. The size and shape was consistent with what the victim had described. She stated immediately after she was struck in the throat, she punched the defendant in self-defense. There was a person who was on a FaceTime call with Miss Almeida when the altercation began. She witnessed part of the incident and told police that she had heard the defendant threaten to beat up and strangle Miss Almeida in the kitchen before Miss Almeida retreated to her bedroom. The witness also stated that the defendant followed Miss Almeida into the bedroom, continued to yell. She then saw the defendant banging on the phone and saw the defendant hit Miss Almeida first. Based on that, the defendant was taken into custody. I will point out that 24 PI 007824 case, the defendant was given a $5,000 surety bond by Judge Oliver on October 25th of 2024. That also involved Miss Keely Almeida. And what is very concerning for the state is in that case, she did try to strangle her with a beaded necklace and grabbed her. So that's especially concerning right now because in this case, she threatened to strangle Miss Almeida, which I believe is why Miss Almeida retreated, because she knew full well, based on the previous case, of what her mother was capable of. We are asking for a $10,000 surety bond on this case, $8,000 on the family violence battery, $2,000 on the simple battery family violence, no further contact with Keely Almeida. Stay away from 3631 Chattahoochee Circle in Roswell, no alcohol, drugs, or weapons. And we are asking for a family violence intervention program based on this most recent case and her case in October of 2024, where there's also allegations of abuse between the family members. We would like to sound for Keely Almeida, and that's all for the state.
If Keely Almeida is on the line and wishes to address the court, now is your opportunity. Does not appear so. Ms. Tucker?
Yes, Your Honor. Miss Almeida is 46 years of age. She's lived in the Atlanta area for 30 years now. She's currently employed at the McDonald's. She just started there recently, actually. She has completed some college focusing on computer science. She has two children, one of whom is a minor that's 14 years of age. In regards to the incident location, we are objecting to a stay away from 3631 Chattahoochee. That is Miss Almeida's residence. She is the only person on the lease. The alleged victim here, her daughter, is 20, was staying there as a guest. Miss Almeida was living homeless. She was homeless prior to getting this residence, and she was very adamant that she needed to be able to keep her residence. She did not want to have to return back to the streets. She does not have any other options in regards to a living situation. So we do ask that she be able to return to the incident location. And we are asking for a signature bond on her behalf. She would not be able to afford a $10,000 surety. And she is concerned about losing her position at her job and possibly returning back to the streets.
And Your Honor, if I may, the reason the state's asking for a stay away and no further contact is because in the October 2024 case, the court ordered no further violent contact. That doesn't seem to be going too well for Miss Almeida. And so that's why the state is concerned for the safety of Keely Almeida, being that, again, the previous case was an allegation of strangulation. Her mother is, according to a witness and to the victim, walking around threatening to strangle her again, and then strikes her in the throat.
But Miss Keely is not on the lease. She is 20 years of age. So she does have the option to pursue other living arrangements. Miss Almeida here just secured this living situation for herself, and her name is solely on the lease. She is the head of household. So we're asking that she's able to maintain her residence.
Well, unless she is properly evicted, then if she's living there, then she's been allowed to live there and she has to be properly evicted from that residence. So if she leaves the residence, I'm gonna allow Miss Jennifer to go back, but if Miss Keeley is still at the residence, then I'm not gonna allow them to be around one
Yes,
another
Your
at the
Honor.
present time, Miss Tucker. So I understand her situation, but Miss Keeley's gonna have to I guess either voluntarily or involuntarily go someplace else before Miss Jennifer can go back there. Okay, so for now, unless there's anything further, for the battery, it'll be a $2,000 good bond. For the simple battery, $1,000 good bond makes for a total of a $3,000 good bond. I believe that the Family Violence Intervention Program would be helpful given the nature uh, of the allegations here and the history. No further contact with Keely Almeida. She can go back to the Chattahoochee Circle address one time with law enforcement. If Miss Kaylee is not there, she can remain there. If Miss Kaylee is there, she'll have to retrieve her belongings and find someplace else to reside in the meantime. No drugs, alcohol, weapons while out on bond. Good luck to you, ma'am.
Position,
We'll see you next time, Officer Melton.
position number 8, Mr. Funkhauser.
We have some good questions.
Good afternoon, Mr. Funkhauser. You have been charged in case 25 CR 003533B with criminal trespass. Is there a history?
91, 2025 trespass conviction. Probations from 23, 22, 2021, 2019 failure to appear, 2018, 17 trespass conviction, 2014 trespass conviction, 2014 failure to appear, 09 trespass conviction. That's
Harrison?
Yes, Your Honor. On June 22nd, officers responded to a call at Racetrack located at 3505 Camp Creek Parkway in reference to a trespassing. When they arrived, they made contact with the manager, who informed them that the defendant had walked onto the property and remained on the property just before 8:30 a.m. of that morning. The manager informed officers that he'd issued a prior criminal trespass warning to the defendant on behalf of the business in August. And that was on August 6th of 2024. It was issued by the East Point Police Department. So officers located the defendant around the racetrack location shortly after this call. While they were still on the scene, they saw him walking on the public sidewalk at the intersection of North Commerce Drive and then step over a metal guardrail onto the grass area of the racetrack property. At that point, they conducted a stop and spoke with the defendant, and he admitted to knowing that he had been issued a prior trespass warning to stay away from this particular racetrack property. Your Honor, the state does have some concerns that the defendant may be residentially challenged. That being said, our recommendation here is $1,000 surety bond due to the defendant knowing that he should not return to this racetrack property as he has been warned prior times by the police and employees there. So we're asking for $1,000 surety bond, a stay away from the incident location, no contact with any employees at this racetrack location, a social worker visit to determine if there are any residential resources available for the defendant, and no drugs, weapons, or alcohol while out on bond. And that'll be all for the state.
Thank you, Ms. Tucker.
Mr. Funkhauser is 58 years of age. He's lived in the Atlanta area for over 30 years. He was able to provide me with a mailing address that he's used consistently. However, he is experiencing homelessness. He says he stays at the Gateway from time to time. He has obtained education up to the 9th grade. He's currently not employed. And due to his financial situation, we are requesting a signature bond on his behalf. He maintains that he only took a seat on the guardrail. He never crossed over onto the Raceway property, that the officers saw him on the sidewalk, which is described in the incident report as well. So we are asking for a signature bond on his behalf.
Okay, it will be $1,000 good bond. No further contact with any employees of the racetrack on Camp Creek Parkway and stay away from that location. Social worker visit to assess for BHUT and housing. No drugs, alcohol, weapons while out on bond. Good luck to you, sir. Courtroom 2, do we have anyone else?
Sir, I would like,
Not in person, Your Honor.
I would like the court to address this. I had all my
Courtroom 2, if you want to go ahead and deal with Mr. Funkhauser there for me, please.
Your Honor, we got 5 waivers.
when did you come on?
Position number 2,
Okay.
position number 3,
Okay, hold on 1 second for me. Let me get these down. So position number 2, what's the announcement?
waiver.
Okay,
Number 3,
position number 3
yes,
is also a waiver.
yes.
Okay,
Number 6,
is also a waiver.
yes.
Okay,
Number 11, oh, I'm sorry, number 9 and 11 also waivers.
okay,
Number 12, bond was posted.
okay, released. Okay,
Number 16, reset behavior.
16 is reset for 6/25.
And if
Okay,
we could make sure that we reset both cases, there was a subsequent filing, I think it was made after the deadline, or wasn't seen after the deadline. I blame myself, but he has an
is
open.
the add-on calendar?
Yes, Your
Was there
Honor,
an
it is the
add-on?
add-on
Great.
calendar.
Yes.
Yes.
Okay,
If we
all
could
right,
put both
Mr.
of those on.
Sirocco.
Thank you, Judge.
You're welcome. We'll reset both the add-on 1 and 16 for tomorrow. Okay,
Position number 17, one of the officers for Alpharetta Jail contacted us to let us know that this person had city charges and he shouldn't have been on the calendar.
okay. And, all right, so that takes care of everyone. Let's just go down. Ms. Falk, you have a question?
So okay, here's the issue with Mr. Tangstrom's case. They may have been city charges, but we accused him on those charges, so now there are charges.
Oh, okay.
That's why I'm making a quizzical face, Your Honor, because
Okay.
unfortunately we have now adopted this case when we accused it. I don't know if we just need to go ahead and bring him and just address it, or if he's going to bond out, because now it technically has moved over to us. I don't think the city court's going to address him, and I don't want him to get stuck in limbo.
So stand by,
Right.
the officer is contacting Alpharetta Jail now.
I appreciate you so much, courtroom 2. Thank you.
Okay, so let's just go down the list with the waivers. We will start with position number 2, Alfred Broughton, charged in case 25 CR 003527E with theft by taking and criminal trespass and damage to property. The history, Mr. Howard?
24. You got to open theft by taking in the cab. On probation in state court for trespass, possession of drug-related objects. Also for theft by taking and trespass out of state court. 2025 probation, couple of probations from 2020, 2018 ag stalking conviction, 2018 violation of family violence order conviction, and he's homeless. That's it.
Thank you. Ms. Falk?
Yes, Your Honor. On this case, this incident happened yesterday at 781 Penn Avenue Northeast in Atlanta. The defendant went on to the property of Mr. Daniel Christopher at around 10 o'clock in the morning. The defendant had taken a yellow wagon and a green and blue marble flower pot worth approximately $100 off the porch of Mr. Christopher around 7:30 to 7:40 a.m. The officers were able to recover the yellow wagon, but the flower pot was damaged when the defendant dropped it on the ground. The flower pot, as you've heard, is worth approximately $100. The issue with Mr. Broughton, Your Honor, is the defendant is currently on probation on 24 CR 006070C. That's a theft by taking and a criminal trespass, where the defendant took a scooter off the porch of Mr. Sexton Stevens. He was placed on probation and actually just spent 17 days in jail on a probation violation, 11 days, excuse me, on a probation violation from May 6th to May 16th because he had not completed the anti-theft or reported. And in that 2024 case, he got a $2,000 surety bond. Because he'd received a $2,000 surety bond on a case very similar to this one, we are asking for the $600 preset bond to be increased to a $3,500 split bond. We're asking for $3,000 surety on the theft, $500 signature through pretrial services on the criminal trespass, no further contact with Daniel Christopher, stay away from 781 Penn Avenue Northeast in Atlanta. We are also asking that he complete the anti-theft course that he has not completed through his current probation, and no alcohol or weapons. Mr. Daniel is here, and Daniel Christopher is here, and if he would like to speak, he will need to unmute and turn on his video.
Yes.
Hello.
Court, if you to raise your right hand for me. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
What would you like to tell the court, sir?
Yeah, I just wanted to kind of reiterate, what I mentioned to the officer yesterday during this incident. The defendant, he also came onto our front porch probably about 2.5 weeks ago, took some less expensive items, and we did notice that he stole some packages from a house on Myrtle Avenue, which is a block over, and left those on our property as well. And I did make a post on Nextdoor. This person, he has been a consistent nuisance for the neighborhood. There are numerous posts from other people with reports of him stealing packages, their plants, cushions, damaging light fixtures, like all sorts of things. So yeah, he's clearly a nuisance for the neighborhood, and I'm just hoping something can be done to prevent this in the future.
Thank you for being here this afternoon, Mr. Christopher.
Thank you, Your Honor.
You're welcome. Ms. Tucker? Is this your case, Ms. Tucker?
Yes, Your Honor. Mr. Broughton is 43 years of age. He's an Atlanta native, and as pretrial services reported, he is currently homeless, and he is not employed. We have no objections to the state's recommendation to a stay away, as well as no contact with Mr. Christopher here. In the anti-theft course, we are, however, requesting a signature bond on both counts due to his financial status at this time.
And I want him to have a social worker visit to assess for BHET and housing issues. For each charge will be a $1,500 good bond, makes for a total of a $3,000 good bond. No further contact with Mr. Christopher. Stay away from the Penn Avenue address, the anti-theft course, no drugs, alcohol, weapons while out on bond. Okay, the next case would be position number 3, Ernest Coer, case number 25 CR 003410A, criminal trespass. Believe that this is the case that we've been trying to get a waiver for the last number of
Several
days.
days.
Yes, is there a history, Mr. Howard?
29. He got 2 open counts of trespass. 25 CR 001 466A. He already has a pretrial bench warrant. 2018 probation, 2015 criminal damage to property, 2nd-degree conviction. That's all.
Thank you. Ms. Falk?
And Your Honor, before we start with Mr. Coer, I do have one request as to these waivers. I would ask that we take position 9 out of order and hold that till last due to the charges.
Okay, very good. Thank you.
Your Honor, this incident took place on June 17th, 2025 at 1722 Campbellton Road Southwest in Atlanta, which is the Chevron. Officers responded to a report of a criminal trespass there, spoke to Mr. Achele, who is an employee at that location, who explained that the defendant had entered the property, refused to leave despite being asked multiple times. The officer had previously personally arrested this defendant for criminal trespass at that location, and the defendant had actually been criminally trespassed from that property in February and March and October of 2024 and March and May of 2025. What you heard from pretrial is correct. The defendant does have an FTA in which he's currently being held, 25 CR 0014661A. He had received a $2,000 signature bond through pretrial services by Judge Mincy, and that was a stay away from the same exact gas station he was trespassing on in this case, and that incident was in March of 2025. He has been arrested several times, you heard, for criminal trespass, and he's currently being held on that FTA as well. We are asking for $1,000 surety, social worker visit, stay away from the Chevron at 1722 Campbellton Road Southwest in Atlanta. No alcohol, drugs, or weapons. That's all for the state.
Ms. Tucker?
Yes, Mr. Coer is 45 years of age. He's an Atlanta native. He was able to give me a mailing address, but I do believe he is currently homeless. He's obtained a high school education. We are also we'll be submitting a request for a social worker visit as well. He is under the belief that he works at the Chevron, but he says he has no objections to a stay away, and he will follow the court orders to stay away from that location. He does have children, and he would not be able to pay a surety bond today due to unemployment. We are requesting a signature bond or the lowest bond that the court would allow. In this matter, we are also requesting that his case be placed on the competency docket.
And Your Honor, my apologies. Prior to it being placed on the competency docket, if we can have that social worker visit just to confirm that it would need to be placed on the competency docket.
Okay. It will be $1,000 good bond. Stay away from the Chevron on Campbellton Road, a social worker visit to assess for an MHET, no drugs, alcohol, weapons while out on bond. I see that we have Alpharetta on the line. Has someone had the opportunity to speak with Mr. Tegstrom?
Yes, Your Honor. He was a regular phone interview prior to court today anyway.
Okay, well, let's go ahead and take up his case next. You can unmute there, Alpharetta, for me. Good afternoon. Mr. Tegstrom, you have been charged in case 25 CR 003540Y with driving under the influence of alcohol, possession of an open alcohol container, and an illegal stop stand park where prohibited. Is there a history, Mr. Howard?
37. 2012 probation. 2009 terrorist threats, criminal damage to property, 2nd-degree conviction. 08 shoplifting conviction. That's
Mr. Sriracha?
Yes, and I'm going to elaborate on that criminal history in a second. It goes a little bit deeper with respect to what's relative to this particular case. The incident took place on June 23rd, 2025 on Dinsmore Road in Milton. Law enforcement observed a vehicle stopped in the westbound right turn lane. It was operated by the defendant. Through investigation, the officer determined that the defendant was less safe under the influence of alcohol while operating said vehicle. He had an open container of an alcoholic beverage in the vehicle and was placed under arrest. He has several prior convictions for DUI, one in 2007, 1990, 1989, 1986, and in 1983, back when NOLOs were available for this. So there's a risk of reoffense here and a threat to public safety, passengers or other pedestrians and individuals on the road. So the state's asking for a $2,500 surety, $1,500 surety on the DUI, and $500 on the remaining charges. No driving unless to court, work, or for medical reasons. And we ask that he be subject to random screening. And that is all for the state.
Mr. McLean?
Your Honor, he went to, he was, let's see, 53, if I do my math right, he is 72. He went to Northside High School, got his GED later. He's self-employed. He's from a big family. I talked to several of them today. He's got all his brother, I believe it was his daughter. He has brothers in the area here in Gainesville and North Fulton County. He's self-employed, painting business, and has a couple of independent contractors or employees, I'm not sure which, that help him paint. He needs to get back to that business. He's got a stable mailing address in Milton, and we do understand that he does have arrest history on it. We would ask the lowest possible bond. If it's not not possible, we would ask the court to consider 1,000, but we would ask the court to consider the age of other similar things to ask for a 60 bond.
For the DUI, it will be a $1,500 good bond. For each of the other charges, a $250 good bond. Makes for a total of a $2,000 good bond. No drugs, alcohol, weapons while out on bond. Good luck to you, sir. Thank you, Alfredo. We appreciate it.
No problem.
Continuing on with the waivers, position number 6, Christopher Evans, charged in case 25 CR 003529J with loitering and prowling, criminal trespass and damage to property, willful obstruction of law enforcement officers. My understanding that this is Mr. Evans's first arrest.
I got a question. McLean, is this MH?
It is, we should probably, I got his mother. Is his mother on?
Yeah,
If she's on, we need to do a breakout or a non-streaming to just hear from the mom, because
Let me hold this until we can go off. Ms. Falk?
Yes, I think I can actually help kind of move this along. Is Miss Evans willing to take custody of Mr. Evans?
Yes.
Or for him to stay there? Okay, because the state's going to recommend a signature bond through pretrial services.
Okay. Wonderful.
Okay.
I just wanted to kind of, if that
Okay.
could help resolve maybe some of the issues on the table.
Thank you.
Okay.
And I can go through, with your honor, just the brief facts of the case. I just was trying to maybe
Thank you,
help
Ms. Falk.
everyone along. Yeah.
Thank you. Yes, go ahead.
Yes, Your Honor. So this happened on June 22nd into June 23rd of 2025. Officers went out to the Church's Chicken at 3667 Campbellton Road. They saw the defendant had damaged the doors of the Church's Chicken restaurant, and the defendant then ran toward the Valero gas station. They saw the defendant, yelled for him. He continued to run. They made contact, had him stop running and lay down on the ground, and was able to successfully place him in handcuffs and place him in the car. As you've heard, the defendant doesn't have a history, and that is why the state's recommendation was a reduction from the $2,800 preset surety bond to a signature bond through pretrial services, a social worker visit, no alcohol, drugs, or weapons, stay away from Church's Chicken at 3667 Campbellton Road, Southwest in Atlanta, no alcohol, drugs, or weapons. We are fine with changing the social worker visit to a comply with any and all medications that the defendant is on.
Mr. McLean, any objection?
No objection, Your Honor. That's not fine.
Okay, so Ms. Evans, as a condition of the bond, I'm gonna have you be a parental co-signer. So you will have to, Mr. McLean will get you that paperwork that you'll need when you sign your son out, okay?
Can I come pick him up today?
It will, he'll be processed out within the next 24 hours, so you probably need to call before you go to make sure that he is being released, okay?
Well, the reason why I asked, Your Honor, is because Christopher is a special needs adult. He has fetal alcohol syndrome. And I've been trying to get him into a program, which he has been on a waiting list for almost 7 years since he's been out of high school. And we recently have gotten his nursing assessment, but he has to be present for that assessment, which occurs tomorrow at 10 a.m. So I was wondering if I could get him today so that we can push him through the cycle, and that way we can get him in the program that he needs to be in so that we may not have any of these outbursts anymore from him.
Okay, so what you're telling me is that basically time is of the essence, so
Yes, sir.
I will try to, Mr. McLean, and if anyone's in, whoever's in courtroom two there, if you can try to process Mr. Evans as quickly as, have them process Mr. Evans as quickly as possible. Ms. Bridgewater, if you will go ahead and get me the paperwork, I can get it over to the jail before the rest of the paperwork, so if nothing further, it'll be $1,000 $1,000 signature bond through pretrial on each charge. Makes for a total of a $3,000 signature bond through pretrial level 1. Stay away from that Church's Chicken. Parental co-signer of Miss Sherry Evans. Take it that the name is spelled correctly on the screen here.
It is.
Comply with any medication that he is currently on, and no drugs, alcohol, weapons while out on bond.
And they wanted me to ask for rep services with this. I'm not really sure why, but I was just letting you know.
Okay,
But it'll be assigned to a MH person in pretrial for supervision, though.
okay, all right,
Yeah.
very good. Thank you. All right,
We could have her chat her email address to me in chat, and I'll if we fail to get it, I'll call her. But just to make sure, since we're still in session, if you could.
I'm doing that now.
Okay, great.
okay. Thank you, Ms. Evans.
Thank you.
You're welcome. Let's see,
Hold on, McLean, you have the link, right?
I will fire up the laptop in here and get it from the previous time we sent it to somebody.
Okay.
Either that or I'll get a colleague to send it, but I think we can probably send it from here. As a forwarding. If you want to do it directly, you can feel free.
okay, it's in the chat, I see it.
Okay.
The next in line is position number 11, Meredith Katz, case 25 CR 003483D, charged with hit and run, failure to report an accident, possession of an open alcohol container, improper erratic lane change, speeding, driving while license was withdrawn, and failing to report striking a fixed object. Is there a history, Mr. Howard?
I didn't do the total, but 2022 disorderly conduct NOLO, 2021 suspended license conviction, 2012 DUI conviction, suspended license conviction, 2011 DUI conviction. I stopped there.
Thank you. Ms. Harrison?
Yes, Your Honor. On June 16th, officers responded to a hit and run location on Paulding Drive. When they got to the scene, they saw a serious motor vehicle accident involving a white BMW and a blue Toyota Land Cruiser. The driver of the white BMW, Miss Amy O'Connell, was on the scene, and she informed officers that the blue Toyota crossed the double yellow line and struck her. Both of the vehicles were disabled and their airbags were deployed. Officers also saw a Chevron road sign had been knocked over. And Ms. O'Connell informed them that the driver of the blue Toyota had actually fled the scene on foot. She gave them a description of a white female with blonde shoulder-length hair, wearing jeans and a black top. And she informed officers that there was another person on the scene, another witness, Miss Osgurdal, who stopped by and spoke to her, and she informed that witness that the driver of the blue vehicle had fled on the scene, and the witness actually followed the defendant on foot and was actually able to speak to her and overheard her on the phone saying to someone, "David is coming. I don't want to get arrested." Officers ran the tag of the blue Toyota and got the registered owner's information. And they made contact with the owner, who was a Miss Janet Katz, and she informed them that her daughter, Miss Meredith Katz, was the driver of the blue Toyota Land Cruiser and typically drives the car. They asked Miss Janet Katz if her daughter had any relations with a man named David, and they were informed that David Healy was an on-again, off-again boyfriend of the defendant. So officers conducted a knock and talk at Mr. Healy's address. He answered the door. He confirmed his identity and informed officers that Miss Katz had called him needing to be picked up from the scene of the emergency. And she was actually hiding in some bushes on the side of the road when he picked her up. They drove by the accident on the way home. So he did see the crash and all the remnants of it. And he knew at the time, he's told officers, he knew that the defendant was involved in the accident. And he stated that she needed to go to jail. Officers did also confirm at the scene that the defendant had prior DUI charges and a number of license cancellations. Also in the vehicle, it was discovered that there was two blue raspberry flavored Vibe alcoholic drinks in the car. One of them had a broken seal, so they believe that the defendant possibly was under the influence of alcohol at the time of the accident. The state's recommendation, in light of the defendant's prior criminal history and her carelessness in leaving the scene the way she did, is a $7,000 surety bond, and we're asking for her to not drive at all without the proper credentials, and that'll be all for the state, Your Honor.
Mr. McLean?
Your Honor, I was able to get hold of her family, Janet Katz, her mom. She's not able right now to be with us. Let me get rid of that chat screen. Thank you. Your Honor, she is I believe it's has a master's degree from a large out-of-state college in architectural design. She does kitchen and bathroom design for 11 years. So she is a professional, creative type person who has her own business. We understand what the previous arrest history is. If a signature bond is not appropriate, we would ask the court to consider that signature bond. But if it is not appropriate, we would ask the court for a $1,000 or possibly a $1,500 surety bond.
Why is Ms. Katz not with us this afternoon?
She's at the vet's with a pet, and she couldn't, because she's with the pet, she couldn't step outside.
No, I'm sorry. I'm Meredith.
Oh, I'm sorry. She has contagious shingles. She's just in medical.
Oh, okay.
Nothing serious, but it was best not to have her in the courtroom.
Okay, thank you. Let's see. For the hit and run, a $2,000 signature bond. These will all be through the jail. For the failure to report, a $500 signature bond. For the possession of an open alcohol container, a $1,000 signature bond. Improper erratic lane change, $500 signature bond. Too fast for conditions, $500 signature bond. Driving without, license withdrawn, a $2,000 signature bond. Failure to report, $500 signature bond. believe that calculates up to a $7,000 signature bond through the jail. No drugs, alcohol, weapons while out on bond. You get that, Ms. Bridgewater?
Hold on 1 second. I was trying to get this order back from you. Hold on. Hit and run 200, failure to whatever.
No, 2,000.
2,000, I'm sorry. Then for the failure, 500 SOB through the jail, possession of alcohol, $1,000 through the jail, improper whatever, I'm making my own little notes, 500 through the jail, too fast for conditions, 500 through the jail, and driving without something, 2,500.
No, 2,000.
Okay, you know what? Okay. I'll come back and get it from you, Judge. Let me get this over. I'm trying to, if you don't mind.
No, you're fine. You're
Okay,
fine.
I'll
I
come
just wanted
back.
to
Let me
make sure
just
that
get
you
this
had,
over
if
to
you,
the jail.
okay.
Okay.
All right, I believe the last one that we have is Gresham, and we need to go off the YouTube, I believe, for that case.
Your Honor, I'm sorry. I was told that position number 16 decided to go ahead and waive this present.
Right, 16 was in felony court, got a no bond, and that took the wind out of the sails, psychologically speaking, decided to say, well, ask the judge for a fair bond. I'm not going anywhere.
Okay, so he is agreed to waive his presence this afternoon?
Yes, Your Honor.
Okay. Ms. Bridgewater, I want to give you the opportunity to get whatever you need to get done before I proceed on, so
Okay,
that you can
if
be
you
with
would,
me.
let's go back to Miss Katz. On the driving hit and run, if you just run through it for me one more time.
Okay, I'm just gonna go down. I won't call out the charges, just go down the list from the top.
Okay,
All right, 2,000, 500, 1,000, 500, 500, 2,000, 500.
got it.
Okay, should all total 7,000.
Gotcha.
Okay,
Thank you.
you're welcome. All right, so now we are going back. To position number 16, Matthew Spear, charged in case 25 CR 003539D with 2 counts of harassing communications and 2 counts of stalking family violence. Is there a history, Mr. Howard?
2023 criminal damage to property. The FS charge is theft by deception. That's it.
Mr. Sirocco?
Yes, bear with me one moment, Judge. I have a number of files open here. I was trying to write everything down.
And
About
Your
time
Honor, this
for that.
also includes the add-on case.
Oh, okay, thank you.
Yep.
And he's also charged in case 25 CR 003543D with 2 counts of battery family violence and 2 counts of simple battery family violence.
That is correct. All right. Thank you for being so patient. So with the add-on case, beginning with that, this incident took place March 22nd, 2025 at 2119 Briar Glen Lane, Southwest in Atlanta. This actually was a delay in reporting the victim, Miss Taylor Flamer, on April 23rd, 2025, came to police headquarters to report an attack that had taken place on March 22nd. The officer spoke with her, and she explained that the defendant, who was her ex-boyfriend and lives with her, had attacked her during an argument. She explained that she and the defendant would argue constantly, and on that day they were arguing when the defendant came at her and started hitting her in the face. The defendant then grabbed her neck. She tried to fight back, but he then picked her up by the neck, lifting her off of the ground and slamming her onto the floor, which caused an electric heater to break. She sustained a split lip, a black eye, and a scratch on her eyelid from the attack. She explained that the reason for delay in reporting was that she had filed a report on April 6, 2025 for a case involving her, one of her children. And she believed that she had also reported this incident, but was told she needed to file a separate report. And also that the defendant had threatened her if she were to go to the police. The victim provided time-stamped photos of her injuries, which she took directly after the incident, showing the inside of her top lip had been split, that her eye was swollen, and that there was a scratch. She also provided a time-stamped video preceding the attack, the end of which sounds like an attack by the defendant on the victim, and a warrant was issued for the defendant's arrest. That's the first case. The second case, the harassing communications and stalking, this incident took place, it was really a series of incidents from early April of this year to late May at 922 Jasmine Parkway in Roswell and 1822 Jasmine Parkway in Roswell. Law enforcement responded to an ongoing harassment issue. Upon arrival, the officer made contact with Miss Flamer, again, the same victim, who explained that her ex-boyfriend, the defendant, had been harassing her via email. This all stemmed from a breakup between the two, wherein the defendant attacked Miss Flamer's daughter. That is a case I will get to briefly. She stated that she broke up with the defendant on April 6th and changed her number on April 7th. On April 10th, however, the defendant started to reach out to her via email using both fake email addresses and his personal, Spear Matthew 923. The defendant sent numerous threatening and harassing emails from April 10th through May 1st, including explicit sexual content stating he hoped that she and her baby would die. On May 1st, the defendant sent emails stating your kid will be fatherless just like your other kids. I hope you and that kid dies. And 922 Jasmine Parkway, here we come. Forgive me if I go through some of these, but I feel it's important. On April 14th, he said, don't need no TPO. Fool, I'm not trying to come around you. Shaking my head, warrant for child abuse is crazy work. 416, I want to F. 426, why you delete our sex videos? I could have used them. Since you're not speaking to me, how the baby doing? Some very explicit remarks following that. 429, he was asking her about her pregnancy. It sounds as though she is pregnant with his child, and stated, I understand the TPO, but can you give me some kind of hint or clue? 430, you're a clown. You effed a peon that couldn't pay a tab. Hope you die giving birth. Your kid, 5-1 the next day, your kid will be a bastard. You're pathetic, and I hope that you and that kid dies. There's more, and it's important to remember that she's responded to none of these emails. On May 23rd, the defendant then called Roswell Police Department dispatch, identifying himself as Mr. Kramer, and falsely reported that his 3-year-old daughter was burned by hot water by his ex-wife. And this is that case that I will get to more in a second, but that is certainly not the case. The defendant also used TikTok to leak Miss Flamer's address and contact info, alongside defamatory content, including videos of her children, where he attempted to get them to state that their mother was abusing them. Miss Flamer received death threats from random social media users due to the defendant's posts. She had a TPO against the defendant, but it hadn't gotten served. She was unable to serve him. Voice comparison was able to confirm that the false 911 caller was, in fact, the defendant, and warrants were issued for his arrest. There are several open cases for which the defendant was also arrested on, including 25 PI, that insurance fraud, theft by deception, buying, selling motor vehicle parts with altered serial numbers, criminal damage to property was a recent indictment in Henry County, 2023, originally arrested but indicted this past March. He has an FTA from out of Decatur that was from April 9th, 2024. Believe that's one of his foreign holds, and also wanted for a probation violation out of Henry County. That's the other foreign hold. He has, but most importantly, the case that I want to get to here is the 25 PI 005062 case. That is the cruelty to children in the first degree. In that case, the warrants were taken out, and he was finally arrested for that alongside this case after she left her young daughter, juvenile JF, solely in the defendant's care. She went to the hospital because she was pregnant and hemorrhaging. And when she got home, she found that JF had second-degree burns to both of her hands and 2 black eyes. When asked what happened, she stated, "Daddy and hot water." The incident went unreported for several days because, as Ms. Flamer explained, she was a victim of domestic violence. So this is what he was trying to get her in trouble for here. The defendant is not just a threat to this woman and her children. He is, from what we're seeing here, in absolute terror. You have the family violence case which came, of course, after the reported threats of her from him toward her about her going to the police. So there's a risk of witness intimidation here. You have the month-long stalking and harassment beginning less than a month after that, despite him knowing full well that she was not speaking with him, and despite his knowledge that she was actively trying to get him served with a TPO. So there's a risk of reoffense here. Then you have the child abuse case. And all in all, we are incredibly concerned for this victim's well-being, her safety. He is a threat to her. And we are asking, therefore, for, on the battery case, a $4,000 total surety, $1,500 on each battery family violence, $500 on each simple battery family violence for him to complete FFIB, have no further contact with Ms. Flamer, stay away from 2119 Briar Glen Lane in Atlanta, no drugs, weapons, or alcohol while out on bond. And with respect to the stalking, harassing case, $6,000 total surety, $1,500 on each charge, no further contact with Ms. Flamer, stay away from 922 Jasmine Parkway in Roswell, and no drugs, weapons, or alcohol while out on bond. We have not been able to speak with Ms. Flamer yet. We certainly were trying to do so with respect to trying to get a strangulation assessment done here, Judge. But we will continue those efforts, and we would nonetheless ask the court to sound for her at this time.
If Ms. Flamer is on the line and wishes to address the court, now is your opportunity. Does not appear so. Mr. McLean?
Your Honor, as I mentioned on the felony, he got no bond. He said, just ask the court to set a fair bond. Your Honor, we would ask the court to set as low as possible a bond for these counts. He has a high school education. He has a stable address here. He has worked in landscaping primarily.
Okay, for each of the battery charges on the add-on calendar will be $1,000 good bond. For each of the simple batteries, a $500 good bond makes for a total of a $3,000 good bond. The Family Violence Intervention Program, no further contact with Ms. Flamer, stay away from the Briar Glen Lane address, no drugs, alcohol, weapons while out on bond. Position number 16, for each of the harassing communications, a $500 good bond. For each of the stalking charges, a $1,000 good bond, makes for a total of a $3,000 good bond. No further contact with Ms. Flamer. Stay away from the Jasmine Parkway address. No drugs, alcohol, weapons while out on bond.
Who was the Glen?
Is there a question? I'm sorry.
Yes, who lives at the one with the word Glen in it?
The Briar Glen Lane address, I believe, that was the first address that was mentioned. I take it that is that Miss Flamer's address, Mr. Sirocco?
I would assume so, based on the events in the warrant. It's not quite clear since there are two addresses at play. Out of an abundance of caution, we're asking for a stay away from both of those addresses.
Okay,
Okay, that's fine because neither one is his address. All right.
okay. All right, so I believe Gresham, position number 9. If this is the one that we need to go off the YouTube for.